Thank you, everyone. We've just about out of time. So after that excellent start to this session, we're now moving on to our second set of papers. Well, the second paper on the comment. We're very lucky here because while we were almost lost one of our commentators due to court work, which obviously can't always affect and change, we've managed, I hope, can it be live? Yes, we can. There we are. We've got our commentator online. So this is a paper called Dishonesty of Mens Rea, and it's being given by Jonathan Turner of the Queen's College, and the comment will be by Catherine Hardcastle of 6 KBW.
Okay, so I think I kind of maybe lost sight whether it's how much I think about this controversial. So maybe think about the knowledge of it. So when we say you think this is all obvious, and hopefully it might say it. But hopefully you will look at the so I want to say something about why this sort of distinctive kind of mens rea, and about how the confusions in the Doge case and anxieties of what are subjective and objective are a result of kind of similar dishonesty to other more familiar and more tractable mens rea. Then I want to say something about the standard that we get in ID or only the first search process, about how it's not a matter of somebody's opinion. I think this makes there's an important distinction between a standard of opinion and a standard that is independent of anything. And let's say something about how I think this makes a difference to the Hayes case, how the court of appeal misunderstood the defence in that case. And there was also been different they understood the argument. And then I'm going to kind of try to restate some of the concerns that I will by then repudiate about ID and Doge in different terms, in a way that rejects the idea that they involve any kind of malicious fiction, that they involve any kind of fiction. But that doesn't mean that they don't have any legitimate concerns about them, there are. Okay, so as regards subjectivity and objectivity, it's well known, I think, that there are two distinctions that these words represent. The first one is the standards of conduct. These standards that make allowance for defendants' characteristics, which characteristics are. And standards we show making allowances for defendants' characteristics are objective. And the second is the distinction between legal tests, which are subjective in the sense of including a reference to the defendant's state of mind, or objective in the sense of being independent of the defendant's state of mind. And I think it's important to keep these two different functions of the term subjective and objective distinct. So if we need labels, you can call the first one normative subjectivity, and the second mental and mental state subjectivity. So there's an example on the handout of from the Peters case in Australia about that, which dishonesty, which I think confuses the two. So Justice Kirby says to require the jury or any tribunal of fact to take into account the standards of ordinary decent people involves a departure from the fundamental principle of our criminal law that the criminal quality of use conduct is generally to be judged by reference to his or her subjective intention, and not to an imputed intention objectively derived. So I think this is a mistake. So the standard of ordinary decent people is a normative standard. If the defendant's conduct is to be assessed by such a standard, then it's to be assessed objectively by a standard that subsists independently of the defendant's own opinions. But this doesn't prevent the same defendant being judged by reference to his or her subjective intention, and not to an imputed intention. We're still interested in her actual intention, what was, as it was really in her mind, and not what a bystander might reasonably have assumed to be her intention, based on a general understanding of human nature or actual causation and so on. So imputing intention and judging by objective standards, objective normative standards, don't have much to do with each other. The defendant is still being judged by her actual intention. For example, her intention to deprive a victim of property belonging to the victim. But isn't being allowed her own normative characterization of that intention as honest. Now, if you think of dishonesty as, if you think of mens rea as the mental element in crime, then we need to identify the mental state of dishonesty. And indeed, in Feely, so the case that kind of sets all this stuff off, Lord Justice Norton says in section 1, subject 1 of the Act 1968, the word dishonestly can only relate to the state of mind of the person who does the act which amounts to appropriation. But it's important to contrast dishonesty as ordinarily understood with what are paradigmatically thought of as states of mind, like belief and knowledge. So these are cognitive states, and conative states like intentions, as states that actually with desire and the will and so on. So belief, intention, knowledge, and so on, attached to propositional content. So I believe that something is the case. We asked whether the defendant believed or knew that the metal was stolen, for instance, or whether the defendant intended to kill. But dishonesty is not like this at all. Right? So dishonesty is a normative assessment of a person's actions, including possibly their mental actions, like their intending. So to bring this out, think of the way that evidence bears on the ascription of, on the one hand, beliefs and intention, and on the other, dishonesty. We infer a person's beliefs and intentions from her actions, as well as from her other attributed beliefs, intentions, and so on. But the evidence is just that, purely evidential. Right? So a subjective test of belief or intention is a question of what propositional content is really in the head. And there are plenty of philosophical complications there I could go into, but probably won't want to. But what about dishonesty? Right? If you attribute dishonesty to a person, the evidence that you cite in support of your ascription of dishonesty is not purely evidential. It's evidential because it's constitutive. Right? So Joe's a really dishonest person. Why? Oh, he embezzled £5,000 of his company's money. We're not supposed to infer the dishonesty from that evidence. We're supposed to regard that evidence as something he did that is constitutive of his dishonesty. So I think what happens in Gauche is that we end up with a so-called test, subjective test of dishonesty that's awkwardly modelled on these tests for cognitive and conative states like belief and intention, states that take propositional content. So the test in Gauche is a test of the defendant's propositional attitude towards what is and isn't regarded as dishonest by reasonable and honest people. So on Lord Hoffman's account, etc., a dishonest state of mind is consciousness that one is transgressing ordinary standards of honest behaviour. So what's important to understand then is that while this is a subjective test of dishonesty of sorts, it's quite a different thing from what we ordinarily think of as subjective mens rea tests. It's not a test of what was in the defendant's mind in the sense that tests of belief and intention are. So I won't spend too long on kind of diagnosing the confusion in Gauche, but I just want to say a little bit about it. But I think that the judgment in Ivy pretty much gets Gauche right. So I think that Ivy is right to say that it's doubtful whether there really were two conflicting lines of authority, a subjective line of authority and an objective line of authority discernible in the cases. There were cases that emphasised the importance of ascertaining what the defendant's beliefs really were, to the extent that those beliefs would make his conduct dishonest. So we needed to know what he believed in order to understand whether his conduct would constitute dishonest behaviour. And these are beliefs as to empirical facts, not beliefs as to normative standards. And in these so-called subjective cases, the question what the defendant believed is important because it coloured the defendant's actions in such ways to determine whether they counted as honest or dishonest. So as I say, I think Lord Hughes explains this very well in Ivy. So I think what happens in Gauche is that Lord Lane sees a mens rea element as a state of mind, and therefore models it on other mens rea elements that are paradigmatically subjective, like belief, knowledge, and so on. And so, you look for a cognitive state here, and what do you find? Well, you find the defendant's knowledge about the moral status of his own actions. And for that to work, there has to be some external standard that can be made the subject of the defendant's belief or knowledge. So this brings me to kind of the main point I want to emphasise here. which is about the distinction between a standard that refers to somebody's opinion and a standard that is independent of anybody's views. So John Spencer aptly characterised the Gauche test as it became kind of understood as the test of what the defendant thought the jury would have thought. So my question is, how did we end up with such a weird test? How could we end up with that? When, as I say, so I haven't read Feely down there, but Feely just said, the standard is the standard of the ordinary decent person. So the answer to how we end up with such a weird test is as a result of the lawyer's aversion, or the certain lawyer's aversion, perhaps I should say, that you can tell me whether this is an unfair characterisation or not. The lawyer's aversion to the very idea of an evaluative standard that's independent of people's opinion. So when faced with a standard of honesty that isn't set out explicitly in the statute, lawyers tend to ask, well, whose standard of honesty is this? And rather than trying to understand what a true standard of honesty might require, they want to peg the standard to someone's thinking about honesty, even if not this particular defendant's. So since on this view all standards are mere opinions, the test is understood as referring to what is honest in the opinion of reasonable and honest people. Evaluative standards on this view are necessarily indexed to evaluators. Instead of the test of the ordinary decent person functioning as kind of imaginative tool, it's treated as a standard constituting opinion. What makes any standard the relevant standard, the thought goes, is that it's the one espoused by the relevant person. I mean, those of you who teach undergraduates might be familiar with, particularly if you teach jurisprudence, be familiar with the way that undergraduates like to define morality in essays. They, well, I will define morality as what people generally think about morality. Well, okay, but what's the morality that they're thinking about in the first place? So, where a test is subjective, the relevant person is the defendant, that is the person who's thinking about the standard. Where a test is objective, the relevant person is the reasonable person or the honest person. And when things get difficult, we want to ask, well, who is this reasonable and honest person? If there's a disagreement about what honesty demands, we need to track down this person, right? Or the relevant group of people and consult their opinion and show me the reasonable person, and then we'll have a standard. So we get commentators noting that a variety of opinions about honesty exists, whereas the test assumes that there's a moral consensus about what counts as honest. We cast around the person of ordinary decent honesty and we fail to find them. And if she can't be found, embodied in the jury perhaps, or in the results of surveys of public opinion or something like that, then we're forced to conclude that there's no standard. Because the very existence of the standard stands or falls on being able to identify what this person thinks. So this way of thinking about evaluative standards, I think, is deeply mistaken. The objective test of honesty isn't a test of what any person thinks about dishonesty. It's a test of what the honest person would do. The honest person is the person who exhibits the virtue of honesty. So the test should be taken to ask not what is honest in the opinion of ordinary decent people, but what is honest according to the standard manifested in the conduct of an ordinary decent person. In other words, to ask what honesty itself demands. Now, it might be objected that this doesn't remove the problem because disagreement persists. So there's no consensus about what standard is manifested in the conduct of an ordinary decent person. And that's true, but it kind of misses the point, or at least it misses my point. So on the first indexed interpretation, disagreement makes the standard itself indeterminate because there's no single opinion of ordinary decent people. The test could only yield an answer on the question of the defendant's dishonesty if there were an opinion of ordinary decent people to refer to. But on the second, non-indexed interpretation, that's not the case. Disagreement doesn't make the standard indeterminate. It just means that juries will inevitably disagree as it is. And I will come back to that. So, just to quickly rebut, at least to a certain extent, a couple of the lines of argument against Ivy then. So, this is Dave John and Carl Ed. I don't pick on anybody in particular, this is to them, because I actually like that a lot, but it's just kind of one statement of the kind of view that I think is mistaken. So they say the standard mandated by the objective test of honesty is that ordinary decent people, as defined by the jurors or magistrates who tried the defendant, the defendant will have had no way of knowing what standard they would apply, when he engaged in the conduct for which he's now on trial. So my response to that is to say, well, the juror's task isn't to define the standard. It's defined independently of what they think. That's what it means to be an objective standard. Their task is to identify it and apply it. The defendant is expected to be ordinarily decently honest, not to work out what a jury's definition of ordinary decent honesty would be and live up to that standard. And similarly, just to kind of draw attention to a parallel that perhaps goes a bit unnoticed, I think. They say the fact that the jury could find that a defendant was dishonest and therefore guilty of a serious criminal offence, even though he didn't appreciate that ordinary decent people would characterise his conduct to be such, conflicts with the sustained dominance of subjectivism in English criminal law. Now, it's a very interesting question about what exactly subjectivism is, which we might be able to get into. But compare how dishonesty works here with how recklessness works. They think, so Ormer here saying that dishonesty is not subjected in the right way because the defendant can't plead in her defence lack of awareness of the right normative standard, the fact that her normative standard fell short of the standard of the ordinary decent person. But there's a similar problem with recklessness if you think it's a problem, because the defendant can't plead in her defence the discrepancy between her own normative standard about what risks it's justifiable to take and the objective standard. Now, that, as far as I know, has never come up as a problem in any case, but it seems to be analogous to the problem in dishonesty with some interesting implications, but we haven't got time to go into those. Okay, so I guess you might think, okay, show me how this makes any difference in practice. So let me talk about Hayes, because I think it does make a difference, and I think it's interesting how it makes a difference in Hayes. So I mean, just to recap, I think Matt's in the work on undergraduates here, so just to indicate that people know, Hayes is a so-called libel rigging case, where Tom Hayes, I think, served half of a 14-year sentence for conspiracy to fraud for his activities in contributing to manipulating the London interbank profit rates during his career as a trader on the derivatives market. So, given the previous writing on the Ghosh test, both academic and judicial, you can see how the defence argument in this case could have been interpreted as a matter of in whose opinion the defendant's conduct must be regarded as dishonest. And I think the Court of Appeal misunderstood the defence in this way. So some of the evidence that the defence sought to introduce did seem to encourage this view, particularly if you're inclined to just take it already. So the defence sought to introduce evidence of the ethos of the banking system at the time regarding LIBOR and the attitudes of the British Banking Association, the Bank of England, and the Financial Services Authority. And these all tend to give the impression that the defence was trying to, as Mr. Justice Cook put it, dilute the standard of honesty required by indexing it, not to the opinion of the reasonable and honest person, but to the opinion or the ethos of people who are working in the same field as the defendant. But, as I said, I think it's a mistake to think that the standard is indexed to anyone's opinion. What the defence was trying to do was to get across what we might call the situatedness of assessments of virtue. The argument wasn't that juries should sometimes be invited to consider not only the opinion of honest and reasonable people, but also the opinions of those within the environment in which the defendant acted. The argument was that the requirements of the ordinary standard of honesty is partly contingent on, amongst other things, the prevailing attitudes and behaviours of those involved in the defendant's activities. So the Court of Appeal just seemed to ignore what I thought was a very ably argued case for the defence here. They said, it's clear in our view that the only purpose of arguing that the evidence to which we referred was relevant was that the jury would be asked to set an objective standard for a market or a group of traders, not the ordinary standards of honest and reasonable people. And some of their comments suggested that they'd been misdirected by the opinion view here. So they say, for instance, there's no authority for the proposition that objective standards of honesty are to be set by a market. And they warn of the damage caused when a market determines its own standards of honesty in this way. But the defence argument doesn't suggest that the market or market actors get to determine the standard of honesty, any more than the jury is supposed to determine or define the standard when they hear a case. The claim is that what counts as honest in a given set of circumstances is partly a function of the behaviour of agents in those circumstances, not that those agents or any agents are free to decide what counts. So what we don't do is take some reasonable and honest people, jury members, for instance, and ask them to consider this course of conduct in isolation and decide whether it's dishonest. What we do is we imagine that the reasonable and honest people are in the defendant's circumstances, having worked in the finance industry for some time, familiar with the practices and so on, and ask whether they might, consistently with their continuing honesty, have acted in the same way. Now, the answer might still be no. Right? It might be that the reasonable, honest person would have objected to libel rigging. It might be that an antecedently honest person who engaged in it would thereby have compromised their honesty. But asking this question is quite different from asking in isolation whether the practice is dishonest. Okay, so I said there's nothing incoherent about, nothing that wants kind of pernicious fiction in the Ivy test. It doesn't doesn't rely disreputedly on a reference to a fictitious category, as every Freer puts it. Nor I think does it run counter to the general preference in English law for subjective tests of mens rea. It's not a state of mind. Rather, it represents an objective standard of conduct that the defendant must meet. In the same way, the defendants must make the objectively right judgment about what risks are and are not justified in order not to be regarded as reckless under the paradigmatically subjective Cunningham test. So some of the complaints about Goshen Ivy, I think, miss their mark for these reasons. But that doesn't mean that Ivy is beyond reproach. And I think that those criticisms actually are onto something, but not quite what they think they're onto. So I think we need to keep two questions distinct here. The first is when we can regard a defendant as culpable in respect of her dishonesty. The second is when we should hold a defendant liable under the criminal law for that dishonesty. So let me illustrate this again by reference to a judicial comment. Lord Lane says in Ghosh that Robin Hood or those ardent anti-vivisectionists who remove animals from vivisection laboratories are acting dishonestly, even though they may consider themselves to be morally justified in doing what they do, because they know that ordinary people would consider these actions to be dishonest. So think about the way to put it. These people are acting dishonestly because they know that ordinary people would consider that action to be dishonest. So the claim here seems to be that a person's action counts as dishonest and is thus open to moral censure on account of the fact that the person knows that ordinary people would consider their action to be dishonest. But that's surely isn't right. We don't generally think that a person couldn't be justly accused of wrongdoing unless she reflected herself on the wrongness or the wrongness according to public opinion of her action and realised it was wrong by that standard. So that, on the face of it, that's what was another criticism of the Ghosh test. So Lord Hughes says in Ivy, the idea that something that's dishonest by ordinary standards can become honest just because the defendant thinks it is may often not be an easy one for jurors to grasp. And he quotes Smith's law of theft. The second limb allows the accused to escape liability when he's made a mistake of fact as to the contemporary standards of honesty. Well, why should that be an excuse? Well, these points are well taken, I think. But the answer is that the best understanding of the purpose of the second limb of the Ghosh test is that it's not supposed to excuse the defendant's dishonesty or negative the defendant's dishonesty. That is, make it the case in some way that the defendant is not actually blamable for their dishonesty, or make it the case that they turn out not to be dishonest after all. But rather, it should be seen as a mens rea requirement that is quite distinct from the defendant's dishonesty itself. So Anthony Duff makes this useful distinction between the objects of liability and the conditions of liability. The objects of liability are those things in respect of which a defendant is culpable. The justification for criminalising what they've done. The conditions of liability are those further conditions that need to be met in order for us to be justified in criminalising their conduct, all things considered. So in this case, the defendant's failure to live up to the objective standard is enough to show that the defendant has been dishonest. It shows that there's enough for the defendant to be liable for. But the second limb of the Ghosh test should be thought of as a condition of liability, a condition that ensures that the defendant has fair warning that her wrongful conduct will attract criminal liability. So, just to finish off then, there's a useful paper by Winnie Chan and Sinister in which they distinguish various different functions of mens rea. So, people talk about mens rea as the fault element or the mental element. We say, well, actually, mens rea has lots of different functions that can't be reduced to any of these things, and one of them is to provide fair warning. So that, I think, is what the second limit of the gauche test is doing. And I guess a lot of people have thought that anyway, but I think it's important to notice that we don't have to say that the gauche test as a whole is a test for dishonesty as such, in order to think that it might be important as giving fair warning. So, well, the first limb tells us whether the person is dishonest or not. The second is serving quite a different function. And this goes to, so I think this kind of raises a whole separate issue, which maybe isn't worth going into detail, but it raises the question of what we mean by subjectivism. Right? So you might think that subjectivism is about preferring mens rea tests that make reference to the defendant's state of mind. But surely the important question is, why do we want tests that refer to the defendant's state of mind? So what Lord Bingham says in GNR about this seems to me quite inadequate. We prefer the subjective test of recklessness because it's important that the defendant's state of mind is culpable. Well, what does it mean to have a culpable state of mind, right? We don't blame states of mind, we blame people. And the question is, why do we blame them? So if subjectivism has something to say about the role that using tests of mens rea that are tests for states of mind plays in ensuring that defendants are culpable, or has something to say about why using mens rea tests that are tests of state of mind has a role to play in ensuring that defendants have fair warning, then that will do some go a lot of the way to explaining why we should be subjectivists. But some of the criticisms that are calculated by Justice Kirby's quote there in Peter's case just kind of miss the point there by confusing subjectivism of one kind with subjectivism of another, and failing to get to grips with why we might think that subjectivism is of the kind I specified is preferable in the first place. Thanks.
So, Catherine, can you hear us okay?
I can hear you. Can you hear me okay?
I think so. There might be some lack of synchronizing between sound and video feed, but if we can hear you, that's at least the key thing. Over to you. Thank you so much for joining us from court.
Well, thanks so much for accommodating me, and I'm very sorry not to be able to join you in person. And thanks also to Jonathan for an immensely thought-provoking paper and discussion. I've only got some short observations to make, but the headline, I suppose, for what I wanted to say is that I am an Ivy apologist. I think that Ivy actually does answer some of these questions, and I think it's a good decision. And the starting point is, as I think Lord Steyn said in Daly, in law context is everything. And the context for Ivy is, I think, chiefly an attempt to draw together the threads of the criminal law and the civil law on dishonesty, and that may be music to that key to understanding the decision, and it was the driving force behind why they had constituted a 5-panel Court of Appeal in Cornelius, and why Sir Brian Leveson had flagged for everyone's attention in the case of Starglade that there were divergent standards of honesty, not only amongst the man on the street, but also between the civil and criminal divisions of the Court of Appeal. There was an unacceptable bifurcation, which was causing real difficulties in cases particularly which straddled the divide. So tax cases frequently raised the difficulty of approaching dishonesty differently depending on whether you were looking at it through civil or criminal eyes. And I think that that is the key to understanding Lord Hughes's comments, and the key paragraph is 74 in Ivy, where he takes as the starting point the decision of Lord Nichols in Royal Brunei, which I think actually is precisely the point that Jonathan has identified in terms of manifest their behaviour. I think that is precisely what Lord Nichols is getting at in the case of Royal Brunei, when he, the relevant paragraph, if anyone is taking a note, is 389 C to F, where he identifies that if your starting point is that there is such a thing as dishonesty, then you have to move then from that concept to one which accepts that dishonesty is a community standard, but it is not one which can vary. You have to have some kind of benchmark of honesty which cannot move according to individuals. The second point I wanted to make about Ivy is I think that the distinction between subjectivity and objectivity in the Ivy test has been significantly overemphasised. The first stage of the Ivy test is an assessment of the subjective state of mind of the defendant, what the defendant actually knew or believed at the time, and having regard to his personal attributes, his experience and his intelligence. The second stage is whether, having regard to the actual state of mind of the defendant, that state of mind is to be considered dishonest, applying the standards of ordinary, decent people. Now, I am aware that there's criticism, and Jonathan hasn't picked up on it, but there's been criticism in academic literature of whether that moves away from approaches to mens rea, as in Lord Bingham in G and subjectivity. My own view about that is that it is analogous to the approach in G, where again the first stage of the test in G is to assess what is the defendant subjectively aware of, i.e. the defendant, and then the objective second stage assessment of whether it's unreasonable to take that risk. Now, that two-stage approach is also something that Lord Hughes picks up on in terms of in the Ivy judgment itself at 66, where he observed that it's not dissimilar to the approach in respect of self-defence. The first stage is to ask what are the facts as they appear to the defendant, subjective. Second stage, objective standard, applied in terms of reasonableness of the response. Now, it seems to me that those patterns are consistent across Ivy and G and the standards in self-defence, and I also think that this ties in to my first point about civil and criminal law, is that, of course, there's been much discussion of the role of juries and the application of jury standards, but it's to be remembered, I think, that we are here in attempting to apply a universal standard of dishonesty, also not just talking about what is in the mind of the jury, but also the application of the objective standard by the single judge in dishonest assistance and breach of trust cases, for example, where the function is to mark the moral fault in the conduct, and that is the work that dishonesty does, derived from the standard, I would say, that must be considered to exist per Nichols in Royal Brunei. Now, I just finally wanted to say something very briefly about Hayes, because I think that is a very, very difficult case. And I should say that I'm instructed by Tom Hayes, and I've appeared in a number of those cases which concern the individuals convicted of the manipulation of the interbank benchmark rates. It's a very difficult case, and I think that Jonathan's criticisms of it are compelling. But the point I would just like to make, or the comment I'd just like to make, is that one way of looking at Hayes is, as Jonathan has identified. Another is to see it in a line of cases which also involves the case of Merchant in the Court of Appeal, and subsequently the case of Birmingham. And the central difficulty in all of these cases, in my comment, would be that these cases fundamentally confused a concept of dishonesty with a concept of falsity. And that lies at the nerve of all of those decisions, that in fact, I would characterize them not as being really dishonesty cases, but that the Court of Appeal was thrown into contortions because one of the key issues in those cases was the fact that there had been a submission made by individual banks. Barclays, say, for the sake of argument, Barclays had made a representation to the British Bankers Association about the rate at which it could borrow. Now, the essence of the fraud that the defendants were accused of was manipulating that submission that was made by the bank to the Bankers Association. But it was an issue in the case whether those submissions were in fact false, as in, were they a false answer because it was a hypothetical question that they were answering, and there was, as a secondary difficulty, no evidence in the case about whether the rate of submission was actually incorrect. So there was a real question about what was a false submission, what was the misrepresentation that was involved in the case. And owing to a series of difficult preliminary rulings, that they ended up in a very narrow channel having to manoeuvre. And the cut-through approach which was used by the trial judges in these cases was to wrap it up in an issue of dishonesty and to say, well, don't worry too much about whether it was true or false. Was it dishonest? Which, as a matter of interest, is quite it's quite a good illustration of the question that Lord Hughes poses almost rhetorically in Ivy about whether you can ever have honest cheating. Here you've got dishonest true statements in the prosecution's case, or dishonest statements, and we don't know whether they're true or false. Now, one way of attacking that, of course, was the approach that was identified in Jonathan's talk, and I found the criticisms of that compelling. But just to flag for anyone who goes back to those cases, I would say that it's important to view them through the lens of a very distorted and difficult background, and one in which dishonesty did a lot of the work of what should otherwise have been distinct elements of the offence, in a way that I would suggest really owes more to the problematic, I mean, my view, highly problematic nature of the offence of conspiracy to defraud. and the ability of prosecutors to manipulate that offence really as a vehicle for a wide-ranging dishonesty offence. But that's all I wanted to say. I mean, I could go on about Hayes for an awful long time, but I'll pause there for questions and response.
And thank you very much.
Just a quick couple of points, because I actually agree with most of that. So I hope what I said wasn't be read as suggesting that I think OSHA is a better decision than I do, because I don't. I think I think it's a better decision to go. The point I was making was that there are good reasons why you, normative reasons why you might think that the second under the ghost test is a good thing. But that's not to say that I think it's, as I said, it's not, that shouldn't make us think that it's part of the test for dishonesty. And nor, and if I didn't say, nor I think should we conclude that that's how we ought to go about giving people fair warning in crimes like theft, and obviously fraud. In fact, I think we should do it in a different way. So I think the actus reus of theft is the real concern here, which should be mutilated to the extent of absurdity, and we should fix that. Rather than using dishonesty. I think we could actually have a law that got rid of dishonesty altogether and would be entirely satisfactory. That's probably all I was saying.
Okay, so we do 10 to questions and answers, but